Judgment in the matter of King Crude Carriers and others against Ridgebury November and others.
Lord Burrows would explain the decision of the court.
This is a relatively rare case where the Supreme Court is required to decide a fundamental and long debated point of principle in the English law of contract. In the Scottish case of Mai Dick in 1881, Lord Watson, with whom Lord Selborne agreed in a three-judge House of Lords, based his decision on the following legal principle. Where a contracting party wrongfully prevents the fulfilment of a condition precedent, that is a precondition, to that party's contractual duty to pay, that condition is treated as being fulfilled. So in the case of Mai Dick itself, the price was being paid for the purchase of a steam-operated digging machine. That payment was subject to a condition precedent in the contract that the machine should be capable of digging out at least 350 cubic yards of clay in a day, and that capability should be tested at a trial at a specified railway cutting belonging to the buyer. Although the machine was delivered as agreed, the buyer, in breach of contract, failed to provide the testing area so that the trial of the machine could not go ahead. Nevertheless, it was held that the seller was entitled to the agreed price. Lord Watson's reasoning was that as the trial did not go ahead because of the buyer's breach, the condition precedent should be treated as if it had been fulfilled. That is, as if the machine had passed its trial. But is the principle applied by Lord Watson in Mai Dick a part of English law as opposed to Scottish law? That has long been a controversial question. Put another way, is there in English law a deemed fulfilment principle, or as alternatively formulated, is there a principle of deemed waiver? While some English cases may be regarded as supporting that principle, which can be helpfully referred to as the Mai Dick principle of law, other cases have rejected it or have cast doubt on it. Academic commentators have also taken different views on the validity of that principle. In the present case, the issue arises in the context of contracts for the sale of 3 ships. Under those 3 contracts, which except for the price were on materially the same terms, the buyers agreed to lodge a deposit of 10% of the purchase price with a specified deposit holder. The deposit was required to be paid within 3 banking days of the deposit holder confirming in writing that the deposit account had been opened. The parties were obliged to provide all necessary documentation for the opening of the account. But in breach of contract, the buyers did not provide the necessary documentation. The sellers therefore terminated the contracts and claimed the deposits in debt, relying on Mai Dick. That is, the sellers argued that the condition precedent for the payment of the deposit, namely the opening of the account, should be deemed to be fulfilled or dispensed with or deemed to be waived, because the buyers had wrongfully failed to provide the necessary documentation for the account to be opened. In contrast, the buyers contended that the seller's sole remedy was in damages, not debt, and that the sellers had suffered no loss because on the assumed facts, the market price for each of the ships was higher at the date of termination than the purchase price. The seller's debt claim, that is, to the payment of the 10% deposit, succeeded in arbitration, failed in the commercial court, but succeeded before the Court of Appeal. The buyers now appeal to the Supreme Court, arguing primarily that there is no Mai Dick principle of law in England and Wales, and nor can contractual interpretation or an implied term assist the sellers in their debt claim in this case. Apart from refuting that primary case of the buyers, the sellers have a secondary case that even if there is no Mackay and Dick principle of law, the deposits accrued due as a debt when the contracts were made, and that the stipulated conditions precedent went only to the time of payment. Put another way, it said that the buyer's breach was a failure in the machinery of payment and did not prevent the accrual of the debt. It would then follow, according to the seller's submissions, that as the right to the debt has accrued, the sellers are entitled to succeed in a debt action even though the contract has been terminated for the buyer's breach. The Supreme Court unanimously allows the buyer's appeal. The judgment is given by myself and Lord Hamblin, with whom Lord Reid, Lord Hodge and Lord Stevens agree. On the primary issue in the case, the Supreme Court accepts the buyer's submissions that there is no Mackay and Dick principle of law in English law. This is for 6 main reasons. First, Lord Watson and Mackay and Dick did not cite or rely upon any English law authorities in support of the principle stated by him. Rather, he relied upon what he understood to be a doctrine borrowed from civil law. Secondly, the English law authorities do not speak with one voice. It's noteworthy that even in the main supporting authorities, the same outcomes might have been reached without relying on the Mackay and Dick principle of law. Thirdly, the Mackay and Dick principle of law is inconsistent with the important decision and long-established law laid down in Colley and Overseas Exporters in 1921 as to when property passes in a contract for the sale of goods, and the same appears to apply also to contracts for the sale of land. Indeed, the Court of Appeal in the present case recognised that the Mackay and Dick principle would need to be limited, but it's not clear how the exceptions formulated by the Court of Appeal would be applied or what their rationale is. Fourthly, the various formulations or explanations of the Mackay and Dick principle of law are all fictional. For example, deemed fulfilment or deemed waiver. Fifthly, as was said by Mr. Justice Scott in Thomson and Asda MFI Group in 1988, the English law of contract in this area proceeds on the basis of the terms of the contract expressed and implied and their interpretation, rather than by way of a fictional fulfilment of a condition precedent. Sixthly, the consequence of rejecting Mackay and Dick as a principle of law does not lead to injustice. Subject to terms to the contrary, where a condition precedent has not been fulfilled because of the debtor's breach of contract, that breach is appropriately and adequately dealt with through the claimant's remedy in damages. Having rejected Mackay and Dick as a principle of law, the Supreme Court goes on to examine whether the application of standard principles of contractual interpretation and implication assists the sellers in this case. Our conclusion is that they do not. The proper interpretation of the contract does not entail, and there is no implied term, that the conditions precedent to the buyer's debt obligation should here be ignored because of the buyer's breach of contract in respect of those conditions. The Supreme Court also rejects the seller's secondary case. The terms laid down in relation to the setting up of the deposit account are conditions precedent to the accrual of the debt and are not merely concerned with the machinery of payment for an already accrued debt. This is strongly supported by the decision of the Court of Appeal in the Blankenstein in 1985, which the Supreme Court approves. It was there held that the right to the deposit did not accrue until after the signing of the contract in question. Similarly, in this case, the contracts are not ones where a distinction is drawn between when the right to the deposit accrues and when it is payable. For all these reasons, the buyer's appeal is allowed.
The court will adjourn.